I'm not your bro. I'm not your man, and I'm not to be interrupted when I'm speaking. Just because you're unsatisfied with the way that I ruled, then that's not my problem.
All right, y'all. Welcome back. Today we're stepping into Judge Perkins' courtroom again, and yup, it's another sovereign citizen who's convinced he knows the law better than every attorney and every judge in the country. This is the type of guy who walks in with full confidence and zero understanding of how court actually works. And you already know how this goes. Loud claims, fake legal phrases, and a judge who is not in the mood to babysit nonsense. Oh, buckle up. Because this one spirals fast.
City of Detroit versus Christopher Perry Lewis, case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Today is the date and time set for a ring on the bench warrant. I'm going to enter not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting, as well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I could tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email? What's your email?
Chris, CHRISLEWIE, Midtown, that's MIDTOWN @gmail.
Chris CHRISL, right?
Yes, EWIE.
So our self-declared legal mastermind can argue constitutional violations, but can't even send an email properly. That's the funniest part. He's demanding justice while struggling with the basic hit send portion of reality. It's always like this with these guys. They act like professors of law, but can't handle step one of communication. And somehow they're still shocked the court isn't taking them seriously.
Okay, I'm resending at the moment.
I'm going to put my email address in the chat and I'll put my email so you'll have it, and send that to me, and we will have an opportunity to read that. I'll confirm that you sent. I'll wait to confirm that you send it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I'm actually just sending it to the prosecutor as well. Daya Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her attachment. If she could send me a confirmation that she received it.
Get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, those motions that it has. All right. I'm going to wait on that. Once I confirm that you gave me that.
After a ridiculous amount of back and forth, he finally gets the motion over to Judge Perkins. And it's not even a wow, strong argument moment. It's more like, oh, this again. Judge Perkins only needs a quick glance to see what this document really is. Recycled sovereign citizen talking points dressed up like a legal filing. And the second he realizes it's getting denied, you can feel the frustration building through the screen.
Let's go back on the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for
Is
a
there any way I can
trial.
get a written? Can I get a written articulation as to why you're denying the motion? Is there
I'm
any way
denying the motion,
I would just
because
appreciate a written excuse. Can I get a
I'm
written
not,
articulation?
I'm not give it to you in writing. I will, what I
Are we
will
on
do,
record? Are we on record?
we're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Here's why this gets denied instantly. Because it's the same copy-paste sovereign citizen script, no victim, no crime, fake jurisdiction, change venue, all of it. And Judge Perkins has seen this movie 1,000 times, so he doesn't need a full reading session to know there's no actual legal foundation here. They don't bring real case law that applies, they don't follow real procedure, and when the court says, no, they treat it like a personal attack. It's not bias, it's just that your argument isn't legally real. And when someone's entire strategy is, I demand it, the court is going to shut that down every single time.
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or giving me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking, for a change of venue. I'm denying that.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying the motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Okay, I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing, as so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there.
A jury of your peers, man, good luck with that. Because what he really wants isn't a jury, it's a judge who just agrees with him. A real trial means real rules, real evidence, and real pushback. And that's exactly what these guys can't stand.
So at the end of the day, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no losses. Okay. And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse, and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no
I'm
victim
not
or
your
no
man.
loss, bro.
I'm not your, listen, I'm not your man.
Look, sir.
Hey,
sir. Hey, sir, respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody.
And this is where he completely exposes the confusion. He keeps yelling Article 1 judge like it's some magic cheat code. Article I courts are a federal concept in specific contexts, but Judge Perkins is a state judge, operating under Michigan's state authority. State courts get their power through the state constitution, backed by the structure of federalism, not whatever Commerce Clause fantasy he's trying to pitch today. He's mixing up legal buzzwords, hoping the court gets intimidated. But Judge Perkins isn't confused. He's just not entertaining it.
I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence, or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, That's all we need. I don't want to hear any
All
more
right,
from you.
cool. It's cool. I
You made
appreciate it.
your record.
You,
Now,
this
don't
due
interrupt
process
me.
that this,
I
this a
didn't
due
interrupt
process
you.
violation. This a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you
Mr.
trying to
Lewis,
start the
Mr.
process over.
Lewis,
They
Mr.
not
Lewis,
prepared to present a case. I'm telling you. They're
Ms.
not prepared to
Harris,
present an
Mr.
injured party,
Rico,
sir.
he
What we
doesn't
doing?
want to be represented.
Uh,
Listen,
Miss,
listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You
Okay,
take
let's do
whatever,
price determined.
wait a minute, let me say it. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it that way, okay?
I love how he's basically saying, I'm not listening to you, like he gets to decide how court works. Oh, the judge does the perfect move. All right then, take it to a jury and present your overwhelming evidence. Because if you're so confident, the courtroom is the exact place to prove it. And if you can't, then the whole act collapses on its own.
I appreciate that, but I would still like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not I'm not even going to hold you to that, but in paragraph 2. Moreover, I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages/losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So we are giving you real justice, because if you say that there's been no crime, then you have a right to a trial. And that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that.
And of course he hits the classic line, "That's not my name." Yeah, bro, and while we're at it, your name is apparently I Don't Consent, with a middle name of Commerce Clause. Judge Perkins squeezes in one last clean jab and keeps it moving, because he's not about to let this turn into a circus. That's the difference. The defendant wants chaos. The judge wants control.
Indicating a clear conflict of interest, I do not wish to proceed with this matter. You don't have to proceed any further because I'm dismissing the case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd, 4.5, for a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion. All right, and you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court is not going to respond to your voice message. The court reporter is going to respond to you coming
The 36th
down.
district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how the appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is a distinct.
Yeah, I was told to call the clerk the day that I was locked out, the moment I was locked out.
We've moved past that getting locked out.
That was my trial date.
Yeah, so I'm giving you another.
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has to say.
All right, guys, that's where we'll wrap this one up. I'm back, I'm locked in, and I'm ready to grind again. Seriously though, shout out to everyone who watched while I was away, because your comments had me laughing the entire time. Drop your thoughts below, because I already know this one is going to spark arguments. If you enjoyed it, hit like. If you didn't, hit dislike. But either way, say something in the comments. And make sure you're subscribed with notifications on, because we've got more courtroom chaos coming. I'm Judge versus Karen TV, and I'm out.